Welcome to StepParenting and Family Law. And this webinar is recorded, and whether you're watching this in real time or whether you're watching the recording, you're in for a treat. So let me admit everybody here. With us today, we have Robyn Ginney. She is a prominent California attorney who specializes in high conflict divorces. Oh boy. She also has a background in psychology, and she was, before she started practicing law, she was in crisis counseling. Interesting background. And I need to say too, because this is about step parenting, Robyn has the unique quality of being an attorney and knowing all about step parenting, having been one herself, and of course, dealing with step parents in her practice. So as I said, for some of you, when you entered the Zoom room, when you're here in the Zoom room, if you could put your questions or comments in the chat room, we'll try to address as many as possible. And so let's get started. Let's get this party going. And Robyn, thank you so much for taking time out to do this. I really appreciate it. It's just great of you. I know you're busy. So I want to ask you first, though. You have a very interesting story about how you got into law, family law, and why you started specializing in high conflict divorces. Would you share that story with us?
So to get into my history, yes, I went to school thinking that I was going to be a forensic profiler for the FBI when I grew up, meaning I went to study psychology. I worked for the Department of Parole and Probation for a while. This was in Las Vegas. And as part of getting my psychology degree, I was a crisis counselor. And in Las Vegas at the time, back in the olden days, before cell phones, actually, I worked in a program that was kind of like a guardian angel program where they had trauma counselors who would be called to any home invasion, any sexual assault, domestic violence, murders, suicides, attempted suicides, any time where they need somebody to come in to do sort of emotional triage. I was sort of called in along with about 13 other people who did that. I had the privilege of working in Las Vegas from Thursday night until Tuesday night every weekend. So I had a lot of very interesting Super Bowl weekends and other things that happened along that line. So a couple of things happened as I was going towards being a psychologist. I decided that I would rather work with helping people get justice and get some closure rather than going and focusing on a therapeutic or sort of an assessment role. So that's how I segued into law school. I entered law school with the firm conviction that I was not going to do tax and I wasn't going to do family law. And so here I am. It worked out just according to plan. I've been doing family law for about 20 years. I use a lot of my psychological background, the profiling, the assessment of risk, assessment of trauma, assessing family dynamics that I used as a crisis counselor and going through the psychology training in almost daily in the work that I do right now. As a family law practitioner, there are a couple different kinds of family law practitioners. There are the ones who solely work with mediation, who only want to help couples through mediation. Generally, that means you don't represent one party or the other, but you meet kind of with both of them and walk them through. There are some attorneys who will also represent one party either actively in the mediation process or sort of on the side to go through the mediation process, just sort of like a counselor on the side. We do a little bit of that. We do a little bit of counseling, but primarily what we do, which is a little different than most family law attorneys, we do the hardcore litigation. We do the trials. We do custody evaluations a lot. We do handle a lot of the cases where there's substance abuse, where there's psychological abuse, there's some sort of emotional issues. Trauma often is unaddressed. narcissism, somebody tries to kidnap the kids and take them to a different country. Generally, a lot of my clients contact me because they're afraid that if they divorce or if they separate from whoever they're with, that person is going to steal all of the money, cut them off financially, kick them out of the house, and try to steal the kids from them. So those are generally the cases that I specialize in, is that sort of work, primarily in California. I also consult all over the country for those kinds of cases because they're a little different than the general, we just don't get along, he's kind of a jerk and she's kind of a bitch, but other than that, other than just not getting along, we think that we're still going to have assets that aren't going to be stolen or anything like that afterwards. So there's a different dynamic that I help other people all over the country and sometimes all over the world work through.
Yeah. That's great to know, because we have represented here people from all over, and so they can use your help if they don't live in California. So tell me, based on all of your experience in court, out of court, what general advice would you give step parents to avoid trouble down the road and stay out of court?
I see step parents playing a few different roles. Often, on the other side of a high conflict divorce, one or both of the parties will enter into another high conflict relationship. So now you're dealing with two people who have a very toxic relationship, and one or the other has now found another parallel relationship that mirrors that toxic relationship. And sometimes it's just one of the parties who does that, and the other party, usually the husband, finds a more stable, sort of emotionally compatible partner. So from what I have seen, generally, men tend to end up in a more stable relationship with a different kind of partner. Women tend to find less stable relationships. So that causes a lot of problems when you're looking at a step-parent dynamic, because usually, and I'm being very stereotypical, but usually the women who are joining up with the men coming out of these toxic relationships are able to provide a level of stability and continuation from a day-to-day perspective for the kids. They tend to be more involved with the kids than the stepfather on the other side, who tends to be less involved. So what you get almost is the bio mom, the biological mom, sort of at odds with bio dad, because she knows that the person doing a lot of the work behind the scenes is the new partner. And there's all those sorts of dynamics. There's the jealousy, the usurpment that tends to create a lot of friction, because you don't want this other woman taking care of your kids, but she's doing it better than the dad does. So maybe it's a good thing, but it's kind of not. And so that tends to just kind of create this ongoing drama that happens, that sort of manifests in continuing custody issues that tend to be about minutia more than the bigger picture. For example, I don't want the new partner driving my kids to school. Dad should do it. He should step up. She shouldn't be doing it. She shouldn't be making their lunches. She shouldn't be going to school meetings. She shouldn't be showing up at all of the practices. He should be doing this rather than her. So those things tend to prolong. If there's return to court, that's kind of how those dynamics play out from my perspective, is a lot of custody issues. One of the other ways that we see step parents come in, which is kind of on the tragic side, is if something happens to one of the parents. Say, for example, in the previous example that I was talking about, where the father has moved on and found a stable female partner, and something happens to him where he either becomes incapacitated or he dies, the step parent, the stepmom, has no rights, has no legal right to custody, has no legal right to keep the kids with her, even though the other parent may not be capable of handling the kids 100% of the time. So often that turns into a different kind of action. We usually do like a guardianship sort of action, a conservatorship sort of thing. So it's not to say that if something tragic happens, there's no legal recourse, but generally there's no legal recourse if the other parent is able to sort of step up and take the kids. So that happens a lot too.
Yeah, interesting. So what advice would you give parents, stepmoms in particular, since I think most of our audience will be stepmoms, for managing those kinds of avoiding the landmines that are so prevalent?
Oof. Yeah. So I've
Or
been
is that my job, Robyn?
Because I've been doing this for 20 years. I was a step parent for about 8 years until we recently ended that relationship. But everything that you sort of learn from working with people through divorces and seeing how step parents come in is entirely different when you're actually going through it, right?
Yeah.
As an attorney, I always get these questions about, I call it stupid parent tricks. You know, we get the daughter back and none of the clothes fit. They're all dirty. The shoes are maybe on the wrong foot. They're 2 sizes too small. So we're forced to take the kid out and make sure that they have brand new clothes, especially starting school, right? Every time they come, the clothes don't fit. Every time they go back, they've got new clothes and new shoes and you never see them again, right? And so they ask me as an attorney, how do we make this stop? And I think that was happening in my own relationship. You know, like I couldn't figure out how to do that in my own life. I can't tell you how to change that,
Yeah.
you know, yours. But it's a very different dynamic from a legal practitioner perspective. It's easy to talk about, oh yeah, you just do that and you just do that. But until you actually go through it, I do think it's one of those things that if you haven't experienced it, you can talk a lot about it, but you don't really know.
Yeah. True enough. So in my experience as a counselor for step parents and coach, I see some red flags. And one of the big red flags is when the divorced couple or the separated couple does not have a formal child custody or child support agreement. And this is a red flag because I see trouble down the road. So can you address that and, you know, what a stepmom can do about that?
So from both a legal and a personal perspective, having some sort of custody orders in place provides just not so much security, but predictability. So you know what days you have, you know what days you don't have. You have the ability to say, you know, 2 weeks from now, this is where the child's going to be. Often that's using maybe a Google Calendar, or maybe, you know, the visitation with the other parent or with you is every other weekend, so you don't need to necessarily do that. But it allows you the ability to point to a document if there's a dispute and say, okay, you had the kids for last Christmas, we're having them for this Christmas. And when we say Christmas, this is what we mean. So it's not a continuing discussion every year about, well, Christmas, is it the last day of school? Is it the Friday of the last week? Is it the beginning of the Monday? Like, was it 4 o'clock? Is it 2 o'clock? Is it 8 o'clock? So it eliminates that extra source of conflict and that extra discussion that you have to go through is just to have that, like, this is what it is. We don't need to discuss it.
Right.
As a step parent, it's easy, maybe if you're the more organized person, to maybe manage sort of the Google Calendar, but it also allows the step parent that sort of predictability. Like, okay, I know that the kids are going to be here this weekend. Maybe I need to plan to do something else. Depending on your relationship with the kids, maybe you want to go shopping an extra time that day, or maybe you want to plan to have a big dinner because all of the kids are going to be there. So the lack of a plan just increases the communication and the dialogue between the two exes, and you don't necessarily want to create more opportunities where they need to talk about something and reach a decision. So as a step parent, the best thing you can do is just sort of help organize and help sort of clarify and eliminate those conversations. But otherwise, there's not much that you can do, because it's sort of the two parents have to figure it out, and they have to figure it out. It's not the step parent's role to figure out the kids' lives and to organize the parents. And that's such a hard line.
Right. So what I know is that divorced parents line the pocketbooks of family law attorneys, right? So because of modifications that happen on the fly, and I'm talking about money, I'm talking about child support modifications. So can you address the issue of when, in good faith, one couple, perhaps somebody loses a job and they say, oh, you don't need to pay as much as we have agreed on, we'll just cut it back. So talk about the dangers in orally, informally modifying child support.
So generally speaking, money is probably the biggest hot button issue, I think, that most step parents deal with. That and what really is my role anyway. But when you're pointing at, this is the hot button issue, it's money. And it's, how is the child support paid? How much is paid? Is it coming out of the joint account? Is it coming out of the separate account? Is it coming out of my account? And the amount that's paid. So generally speaking, because we are going to talk a bit more about money during this webinar, but generally speaking, if there is an order for support, that order is tied to a specific timeshare, at least in California and in most states and countries. This is how we do it. Texas and a couple of other places are countries unto themselves, but generally speaking, it's a percentage of timeshare and the incomes of both of the parents, not the step parent, not the current or future spouses of the parents, but just the parents. And any modification to either of those things, the timeshare or the income of the parties, will change the amount of child support that's payable. But if there's an order that says the payment of child support is $1,000 a month from father to mother, and you change that order verbally, that modification doesn't exist. And how that plays out is what I often see is somebody coming in after with a 5-year-old order that says, okay, father should pay mother $1,000 a month. And within the first year after that order was issued, there's an oral agreement between both of the parents. Maybe father loses his job, maybe mom gets a job, and they discuss amongst themselves, nothing in writing, saying, well, maybe we just drop that down to $200 a month. And they both agree and they go on their merry way, and he starts paying $200 a month. The problem comes up in California and in a lot of jurisdictions that mother can come back at any time, 50 years later, and say, there was an order for $1,000 a month. He didn't pay anything against that order. And now it's his responsibility in every jurisdiction to show that he actually made those payments. And if he didn't make the $1,000 a month, that the reason that he didn't make $1,000 a month was a legally enforceable modification, which means it has to be in writing. So if it's not in writing, it doesn't exist. And my second caveat, always keep records, because especially if the relationship between the parents is toxic, you want to make sure that there's a canceled check, or that the payments are going through somebody like Department of Child Support Services or whoever the county organization is that collects the child support and then pays it to the recipient, because they will keep track of those records. And that protects both sides. Because if there is an outstanding arrears, at least in California and in most community property states, if he has this $200,000 arrear against this 5-year-old order, but there's this verbal modification, and now the wife is saying now it's $200,000, one of two things happens. You get legal interest, which is 10% a year in California, which is obnoxious. Most states, every state will have their own different calculation. Different countries also have the different calculations for arrears, but that will follow you everywhere. You can't get rid of it in bankruptcy. You can't just charge it as a debt. And they can garnish not only the parents' bank accounts to pay that arrears, but any community accounts, which means any joint account, any joint 401k, any joint savings, They can lean in some cases, not in California, but in some places, they can lean against the house that may be held in joint tenancy. So you can get wrapped up, even though it's not your debt. The joint assets, the community assets can be tapped to pay those arrears. So it's very, very important if there's any modification to support anything involving money, it needs to be in writing. And a text message is fine if you keep the text message and you print it out and save it someplace. Emails are better because they tend to just stay longer in your inbox. Maybe you put it in a special folder, but the best way to modify an order is to actually change the order of the court. Generally speaking, there are a number of places online. There's a place called Hello Divorce that will help with this. There are paralegal services. Literally all you have to do is have a document that looks like a legal pleading, whatever the jurisdiction requires. Sometimes it's a form and sometimes it's something you actually have to create that says the prior order was 1,000, parties agree that it's now this, commencing on this date. And then you both sign it. And that's all that you need to do. But now the court has a written record and you have a written record, and there's something to go back to say, no, this is why we're doing this. So it doesn't have to be a complicated process. It just has to be memorialized in writing. And it's better if both of you sign that thing, whatever that is.
That is so good to know, Robyn, because I think one of the reasons that divorced or separated couples don't go through the courts is they think it's going to be cumbersome, it's going to be expensive, and you're saying not so.
Not so. It literally, it's a contract. And a contract just needs to have, the terms need to be understood by both of the parties, and it needs to be signed by both of the parties. It doesn't even necessarily need to be filed with the court. It just, it's easier if you do that because then the court has the copy and you don't have to worry about where you put it when 10 years later it becomes an issue. So it's better to do that. But yeah, if you just have something in writing signed by both parties, that's all you need. And that protects both parties.
Great. Okay, so while we're still talking, I know we have a lot of stuff to talk about in terms of money, but in terms of custody, a question came up from someone listening that what about a child who decides at a certain age that they want to modify the custody arrangement? They want to go live with one parent instead of going back and forth or whatever the arrangement was. How does that work? When a child wants to change the custody arrangement?
So this is an area that's kind of in flux right now. A lot of the more recent work that's being done in the custody field by a lot of the top psychologists and child therapists and child-focused parental coordinators and those sorts of people are really trying to figure out where that line is between child autonomy and the fact that you're still talking about a child. And how much should that child be responsible for making decisions that impact their longer term sort of growth? In California, and California sort of leads the country, California is very much the child needs to be protected. And so they should not be involved in making decisions and being sort of put in the middle of those decisions before the age of 14. And so what that tends to look like is a lot of the time, and I would say this applies in most places except Texas, and I can talk about Texas if you want in a second, but generally speaking, the wishes of the children before their age 14 are discounted in the United States. In Texas, as you're going through divorce, they give you a de facto 50-50. It doesn't matter what the kids think, unless you have a really good reason to not have it be 50-50. Even if they've never had 50-50, you get an order from a Texas court, it's going to be 50-50. Other places in the world, though, are much more child-centered, and I think America's kind of struggling to catch up with this because the mentality in America is a little bit different. But generally speaking, like Canada, England, most of Europe, Australia, not so much Japan, and not so much South America, and Saudi Arabia, not at all. But generally, they're more child focused in the sense that the kids have a lot more say at a much earlier age, sometimes as early as 8. in what they want and why. This is almost completely discounted in America, but they will have more access to appointed child therapists, what we call in California minors counsel, which is an attorney that's appointed for the child, not for the parents. There are also some court conciliators that get appointed during the Canadian process and sort of in England and Europe that will deal with talking to the child. And if there's a therapist, they'll talk to the therapist and sort of take the child's viewpoints and present it to the court in the way that the court wants it. And how the court wants it changes from literally jurisdiction to jurisdiction, from county to county. You know, one judge wants this, one judge wants that. So it's easier to get an attorney who focuses in that sort of county or that limited jurisdiction. So they'll know, like, well, this judge kind of wants to see this and this judge kind of wants to see that. But generally speaking, say in Canada and England, what they will do is they will ask the child, usually through a mediator, through the court or some sort of intermediary, as part of the custody process. They will actually ask them, you know, what is it that you want? What is your preference? And they will actually respect the child's wishes. In California, we have sort of a similar mandate, like you have to talk to a child if they're 14. In Canada, there's no like you have to talk to a child at 14. It's more like the wishes of the children are always considered. So there's no like you have to wait until they're 14. They always have more of a voice and a process. So there's no like hard, as far as I know, there's no hard like they have to be 14. Of course, the older they get, the more of a say that they have and where they want to go and why. But generally speaking, that's how the court considers what they want.
And the judge is the ultimate decider then about whether it's a legitimate request or it is in the best interest of the child. Is that true?
Generally, yes, because the judge wants to make sure, and this is becoming a sort of a new trend too, a sort of parallel with this, let's empower the child. They want to make sure that there's not one parent that's pressuring the kid into separating from the other parent, that there's no behind the scenes sort of thing that's going on that is not quite right, because that isn't in the best interest of the child. Because if a child has been, 50-50 and all of a sudden says, I want no relationship with dad, I don't want to see him at all, then the court isn't going to be like, well, that's what the kid wants, I'm going to do that. The court's going to be like, wait a second, she's going from 50 to 0. So what's going on here? Maybe it's legitimate. Maybe they had a falling out, but maybe there's something else going on here that we need to consider. So they're not going to rubber stamp, anything that the kid sort of puts forward. There is going to be an investigation. But if it's sort of like, I don't want to be at dad's house during school days, or I don't want this 2-2-3 that America is so fixed, like Monday and Tuesday with mom and Wednesday and Thursday with dad, that gets so confusing for kids as soon as they get into middle school, especially for girls. They're just, they've got their own lives going on. So they don't want to have to, so maybe the kid is saying, I don't want the weekdays with dad because it's just, he doesn't ever let me go to my girlfriend's house or whatever. So that is much more likely to get pushed through in any jurisdiction than a complete change from what the status quo is.
Okay. So if a child comes to a parent and says, I want to live with you full time or most of the time, what is the process then? I know it's probably different in different places, but generally, what would the process be like?
So there's sort of the hard way and the easy way, right? The easy way is you talk to the other parent and say, this is what they're telling me. And usually it's not a surprise to the parent that is losing custody. Usually there's a lead up of, a lot of fighting about curfews or homework or whatever. So it's usually not out of the blue that the child says this, I want to make this big change. So generally there is sort of a lead up to, okay, the child came to me and said that they don't want to do this, or they want to change the schedule this way. They're not saying I want to see you. They're just saying that they want to change things a little because they're getting older, because they've got these new things. And you can work out usually, and it's usually involving the three of you in what does this change look like? changes to custody, because they don't have these long sort of tailing repercussions like monetary changes do, they don't necessarily need to be in writing. If you think that the police are going to be called to enforce a prior order, then you might want to have something in writing if it's that high conflict. But if it's generally just, let's try this for a while, let's see, how things, maybe they just need to settle down, maybe it's a readjustment, whatever, maybe it's a step parent coming in that they don't want to be there right now, whatever that is. That's sort of the easy way to do it. You can do an informal agreement. It doesn't have to be in writing. It can be sort of a, let's see how things go. And every week it may be different. The hard way is after you have that discussion and realize that the parent is going to double down because whatever reason, then you would have to file a motion and bring that action to the court. And in whatever jurisdiction it is, there would be some other supports that come in when you file that custody motion, whether you're going to mediation that includes the kid, whether somebody talks to the kid to get their information to present it directly to the court, however that next process is in whatever jurisdiction you're in.
Interesting. That is great to know that if everyone's on board, you can just do it informally.
Yeah.
Great. Okay. Should we start talking about money?
Yeah.
This is the flashpoint, money. And I really do want to, I know that several people have asked about prenups and postnups and when they're appropriate, how to handle it. There's a lot of misinformation about who should even be talking about this kind of pre or postnup. So can you talk about the advantages, the disadvantages, anything, any light you can shed on this topic?
So as a step parent marrying the biological parent, a prenup can be helpful to define sort of the starting point of the community assets and where those assets fall. So in California and in the majority of the United States that are community property states, anything that the parent has entering into a marriage with a step parent is going to be their separate property. Often this involves a house that they got in the previous divorce. Now it's awarded to them. It's titled entirely in their name. Anybody marrying in step parent, anybody marrying in is not going to have a claim to that house except any sort of community assets that were sort of poured into the house afterwards. This becomes important how you handle this house when you start talking about planning for a probate action or trust or estate, that sort of thing. When one of you dies, what happens and what are the expectations of the kids? And that's a whole other webinar that I know you have gone into. But a prenup could be very helpful in establishing the expectations of, if we divorce, this happens, but also if one of us dies, this is the assets that we're talking about. These are our assets as opposed to the previous parent or the previous marital relation assets. So a prenup is helpful for saying, we have this house, we know we have this house, this is what's going to happen to the house. It's either going to stay dad's or it's going to be ours, and we're going to take it as joint tenants. And then if we divorce, we will take half, that sort of stuff. And prenups can establish what spousal support is, what child support is for the children of that relationship. But it can also establish what happens if on divorce, there are substantial payments that the step parent has made towards the child support or the spousal support, or even the other debts of the parent, of the non-step parent, right? Because often you're coming in and the community will set up a joint account and both parties will put some or all of their money into this joint account. And then from that joint account, the previous relationship child support or spousal support obligation comes out of that. And that is always a hot button issue. There is, as far as I know, no really great remedy to sort of get over the emotional sort of trigger effect of that money coming out of a joint account. There is the ability in most places to claw back the the community portion of the amount that was paid towards child support. So for an example, if over the course of the relationship, there was $10,000 in child support payments that were made out of a community account that both parties, the step parent and the parent, put money into, and now 10,000 is going out to the previous wife, let's say. Upon divorce of the parent and the step parent, you can say that the community needs to be reimbursed for the separate property debt, meaning I as the step parent get $5,000 back, which is my half of what was paid to them. So you wouldn't get all of it back because half of it was his too. But you can ascertain the pay down of those separate debts, because it's not the debt of the step parent. You don't step into that role as soon as you get married. That stays with the parent. So that is an option, and that can be defined in a prenup. It can also be defined in a post-nup. A post-nup is just a prenup that happens after you get married. You don't see those a lot, because generally the only reason that you would enter into a post-nup is because you're having difficulties in the relationship and you're probably really thinking about a divorce, but you're not ready for a divorce yet. So that's generally how I see post-nups coming up. But you can do that in either way.
Interesting. Well, even for prenups, it gets tricky proposing one, doesn't it?
Oh, yeah.
So I don't know if this is in your wheelhouse, Robyn, but how would you recommend that, for example, a stepmom who's about to enter into a legal marriage propose a prenup without seeming like, well, we might get divorced. So that's what I'm thinking. I mean, nobody enters into a relationship thinking it's going to end, right?
Yeah. And that's always difficult. And you don't want to start with the sort of, the best predictor of the future is the past, because you don't want to think that this relationship is not going to be different than the prior relationship. But the fact is, usually the divorce process has been difficult to go through for anybody who has gone through it. And what a prenup can do is clarify that process. So one way to approach it is, this was difficult for both of us the last time we went through this. And the things that made it difficult was figuring out what to do with the property and figuring out what to do with support. Let's just take that off the table now when we're getting along, when we have the ability to work through it on a less emotionally triggered level. And let's just plan for this. And the other part of that planning is, we need to be clear if something should happen to either of us. Let's set out in a prenup what is community property for estate planning purposes and what's separate property for estate planning purposes, so that I can make my trust in knowing what has been determined to be community and separate. And so you can start planning that way. And there's a document that memorializes that agreement if one of you is no longer in the picture.
Interesting. So you said it's post-nups get a little trickier. Is there, since I know that many of the people listening are already, married to their spouses, so that's already happened, so prenup wouldn't be appropriate. Is there a way to soften the blow, to ask for a post-nup without thinking, okay, this is the beginning of the end?
Usually a post-nup that's not sort of, I'm unhappy in the relationship and sort of pre-planning a divorce. Usually there's something that triggers it, and it can be estate planning. And that's a really good excuse, is that you talk to a probate attorney and they're saying, well, we can fund your trust, but we need to know what the assets are that are going into it. You need it defined. And since the house is still in his name, I don't know if you're treating this as a community asset or not. So we need a document that clarifies that. So that's really helpful when you get a third party who's asking for this clarification, and it's not necessarily coming from you. So that's kind of one way to approach it. Another way that I see post-nups becoming important is if there's some sort of substance abuse issue or an accident that happened, like there's a personal injury claim against somebody, that you need to have a definition of what's ours and what's his. for liability purposes. But there's also that discussion of, in any relationship, not just a step-parent and parent relationship, but in any relationship where you start saying the way that we're doing things isn't working for me. And the reason it's not working for me is because I feel this way. And usually the post-nup is about money. It's not necessarily property. It's, am I going to be protected? Am I going to get what I think, not only what I think I have first so that I can plan for the future, but how do I also get reimbursed for these things that I'm paying out, like child support and spousal support to a previous relationship that's just really not working for me anymore. And this is me throwing down the gauntlet saying, I need this to be addressed before it becomes such a big issue that it's insurmountable. Because when you're talking about the payment of child support to a previous relationship or spousal support to a previous relationship that's coming out of joint funds, you're never really talking about money. You're talking about the emotional factor is in the making of that payment, and why you should be responsible for the making of any payment to a previous relationship. So it's about the values and the morals or the idea of what that money represents more than the actual payment. And that's why I kind of think, a post-nup is one way to talk about the money aspect, the actual $1,000 that's going out each day, but there's a bigger or each month, but there's a bigger conversation that needs to happen about why this isn't okay and why that hasn't been addressed so far, because that's when the conversations get really interesting.
Yeah, that is such good advice, that money is not necessarily about money.
Right.
It's, I have been known to say, we can't sue for lost love.
Exactly.
So we go through the courts when we really should be going through therapists, right? So besides the prenup and the postnup, are there any other things that step parents, stepmoms in particular, can do to protect their assets and their resources?
So this generally comes down to, is it a joint or is it separate? And I'm a big proponent of joint for some things and separate for everything else, because it's one thing to be in a relationship with somebody that you're sharing your life with and sharing their kids and their lives. But there's also this need to sort of protect yourself in case the worst thing happens, right? So as often what I will see in a step parent divorce is that the step parent often doesn't have a complete picture of the finances. And so they're taken by surprise when upon divorce, all of everything becomes a different division than what they thought that was going on in their head. So I always encourage everybody to be very involved in where the assets are, what assets are there, who the beneficiaries are on those assets, because even though your name is listed on an account, they could have the beneficiary not be you, or worse, be the name of the previous spouse, and they just never got around to changing it. And that happens a lot, because even though they have a divorce decree that says the entirety of this 401k is now awarded to dad, but he never changes the beneficiary from his ex-wife on that 401k, that trumps the divorce decree. So you don't want that surprise if, your new spouse passes away and all of the assets are listed a beneficiary that's the ex-spouse and you get nothing.
And it's dreadful.
Yeah.
So what should our stepmoms do? I mean, ask to see all the documents? What do you suggest?
I think that's always helpful. Yeah, just so that worst case. And things like powers of attorney, who has the power of attorney? Is there an old trust that maybe gave a power of attorney to the ex? And that just needs to be revoked, because revoking a power of attorney is an easy enough thing, as well as setting up a new power of attorney is an easy enough thing to just make sure that it's the current person instead of the ex person. So those sorts of things, estate planning is a huge thing. Beneficiaries are a huge thing. Making sure that you know the passwords and where the accounts are and how much are in the accounts in case worse thing happens. But that's not necessarily different for step parents, except for this, the beneficiaries, you do just kind of want to do a checkup that the beneficiaries are not, the previous spouse. And sometimes in a divorce decree, there is an order that says that she has to remain, like the ex-spouse needs to remain as the beneficiary of certain accounts. And maybe you don't know about that. Maybe they forgot about that. So that's also something you want to be a little clear about.
Yeah, that's great advice, Robyn. So is there anything that I should have asked you about step parenting and family law that I neglected to ask?
I know that there was a question about how much the new spouse's income is considered in determining support and what happens when you've got your own kids.
Yes.
Support is handled. So I can, generally speaking, and then I'm going to parse these two out. The way that support is calculated, and if anybody's interested, I can show you how we do it in California. But the tax implications that are tied to your income are considered an income available for support. Because if you're in the $100,000 tax bracket, you're paying taxes at X rate, but if you're in the $200,000 tax bracket, you're paying higher taxes. So often what I get is the parent doesn't want to include the ex or the new spouse's income because they don't want all of the income to be lumped together as now all of this is available for support. And that's not how any jurisdiction considers it. It's still only the parent's responsibility. So it's only the parent's income that is considered. But because you're usually filing a joint tax return, your income as the step parent actually is important to put into those calculations to the extent that it bumps you up to a higher tax bracket. So it does make a difference, and it can be sometimes a very large difference, $100, $200, $500 a month. If with your income, they go from a 22% tax bracket to a 30% tax bracket. Now they have less income in their column available for support. So that is a common misconception when we're looking at running support figures, that the step parent is sort of like, leave me out of this. I don't want to disclose my income. It can't be considered income available for support.
Good to know. But filing jointly will help.
Will help, yes. You always get a better tax structure.
Yeah.
Than separate. Yeah.
Yeah, excellent, excellent. So yes, and again, I want to say, if anyone seeing this live wants to put anything in chat, a question, we can probably take a couple of questions. I think, let's see. So Robyn, while we're seeing if anybody else has any questions, how should people get in touch with you? And, I know that you offer consultations outside of California. Maybe you can again parse that out a little bit. Is what's the best way to get in touch with you?
The best way to get in touch with me is probably direct email, and I can put that in the chat if that's easier. It's robyn@heartginney.com, and our website is heartginney.com. What we do is we try to mostly work on the psychological dynamics that are at play in divorce. And that doesn't change whatever jurisdiction you're in. It's all sort of, how do you communicate with the other side when all communication is broken down? How do you get done is kind of what we focus on. However that is, whether that's going to trial, whether that's trying to reframe the narrative about what we're talking about and taking a lot of the drama out of it so you can just focus on these things. And sometimes it's how do you deal with somebody who's got mental health issues, or who's dangerous, or who's threatening? How do you get done with that person who is either completely disengaged or has taken over everything? So I'll also talk about that. I won't go to court in any other jurisdiction, but to understand the psychological game that's being played, That's the same everywhere.
Oh, great. So our population, our step parent community, they can get in touch with you just for a consultation and not to represent them. In
Right.
other words, if they live in, we've got people in Canada, we've got people in the UK, all over the place.
Yeah. And often if it's outside of the jurisdiction, I'll set up a call with their attorney, because usually their attorney is saying, I don't know, I've never had a case like this before. I don't know what's going on. I don't know why we're not getting whatever. Or we have a judge who just is not issuing the orders that we need. And I don't know how to get this judge on board to see what's actually going on. I can come in and say, okay, so as a judge, this is what I'm seeing. This is how you want to change the narrative so that the judge sees what you're trying to tell them, instead of just another case where the parents just don't get along. So it's sort of reframing the narrative. I do a question in the chat really briefly. Most jurisdictions, when considering support, will factor in the amount of child support that is required to maintain a child of the current relationship. In California, we call that a hardship factor. It's called different things in every jurisdiction that you go to, but they will basically subtract a standard amount that they figure is what a child requires to be supported based on some esoteric calculation that nobody quite knows. It's like magic, but they will say, generally speaking, if you have a new child in this relationship, you'll take $1,400 or $2,300 off the top of your income per month available for support. And that will change the support obligation to a prior relationship's children. It usually decreases it substantially in doing that. So they do consider it. In California, they do. There's a form that we use that we just put a hardship factor in. So they all have a certain way of calculating it. You just have to you have to bring that up. It's not standard. Anytime you're running a support calculation, you have to go an extra step to add that. Oh, and there's a child in this relationship too. So it is considered, yeah.
Yeah, wonderful, wonderful. Okay, I have one more question that I wanted to ask before we wrap this up. I know, in California, collaborative law has gained a lot of traction. And can you talk about the pros and cons from your perspective of collaborative law versus what you do, which is litigation, right?
So collaborative law is a really great idea in theory. And if you can get along, so this is kind of my base. If you have ever in the history of your relationship been able to sit down and amicably work out an agreement to an issue that you both can live with and walk away. If you can address a really thorny issue, reach a conclusion and walk away and not come back and argue about it over and over again, then collaboration might be an appropriate choice for you. Like if you decided you're going your separate ways, but you've got a lot of balls in the air, you've got a business, you've got houses, you've got, multiple streams of income, you've got step parents and kids and parents, all that sort of stuff going on. It's helpful in the sense that both of you come in with a team, and that team is sort of like team us. And everybody is working at defining what the business assets are, what the community assets are, what the separate property, and everybody's working together as a team to go through these issues. If, however, you're in a relationship that you've never been able to sit down and reach an agreement that was equal, you may reach an agreement, but it's generally not your agreement. It's just they're telling you how it's going to be, and we're sort of like, okay, I guess that's how it's going to be. That is not a good way to enter into collaborative, because that usually means that one party is just going to get everything that they want, and you're going to be like, well, I went through a lot of this for nothing. So in unequal power distribution relationships, collaboration, just like mediation, I don't think is appropriate, because what happens is you spend an awful lot of money on a bunch of experts to work with both of you. And then if it falls apart because one of you is intractable, then all of those experts that you spent a lot of time and money on cannot work with the next attorney. They are all conflicted out, which means I don't do collaborative law. So when I get a collaborative case, I'm literally starting from scratch and bringing in new experts to reinvent the wheel, and they have to pay twice for work that's already been done. And it ends up spending more of the community resources than if you had just started out with an attorney just representing yourself from the outset.
Yeah, that's good. I love how you distinguish between the two. So, Robyn, what about starting with a mediator before hiring an attorney? Is that something that you advise people to do?
70% of cases can be resolved through mediation. So it's a great statistic. I represent the sides of the bell curve, right? Not everybody needs an attorney to go through. Most of the time, all you need is somebody to say, this is the document you need to fill out. These are the forms that you need to fill out. You have an agreement on everything. Let me write it down in the way that the court wants to see it. And that's generally what people need. And generally speaking, mediation is a fine choice.
Oh, that is great. That is great. We have another question.
Yeah, there are attorneys who you can meet with before you start mediation who will be consulting on the side. I work with a lot of people who are going through mediation without me. And then they'll come back and say, okay, we met with the mediators, kind of what we talked about. What are my options when I'm looking at the house? Because maybe the mediator's sort of like, well, what do you want to do with the house? And you're like, I don't know what I want to do with the house. Like, what can I do? And then so you talk with me about, well, you could do this, you can do that, you can do that. You can, and often part of the consulting is bringing in like a financial planner or a probated estate person to say, okay, let's look at if you take the house, then what happens, 5-10 years from now? And what happens if you don't take the house? Then you get this. Okay, so what do you do with that? And what does that look like 5 or 10 years from now? So you can have your whole team on the side that never goes to mediation, but it just gives you enough information to feel like when you're talking in mediation about options, you're more informed about what options exist and the pros and cons of those you may not go through in mediation.
Yeah. Robyn, this has been fabulous. Thank you so much. You are just a wealth of information, and I have learned so much, and I trust that anyone listening learned a lot. So I so appreciate that you gave up an hour of your valuable time. Thank you.
My pleasure. Thank you.
Thank you. Thanks, everybody. Bye.